Hey guys, what's up? So you have watched the DPSP 4.1 plus 10 videos before that in the Polity series. If you haven't done that, please watch all the 11 videos before proceeding here. You can find the link to the playlist in the description below. So this is the part 4.2 and this is presented by me. This is the YouTube channel Unacademy. So many people are asking me for making videos on how to make notes, how to write answers in mains, how to introduction to geography, ethics, economics. Some are also asking for reading comprehension. So please choose, and whatever is your poison, let me know whichever you want me to make on. I'll do that. And how will you do that? You have to comment below the video, hit the thumbs up on YouTube and on the Facebook page as well. So I'll know that which is the demanded video and I'll make that. So by 24th Constitutional Amendment Act of 1971, what happened in 1951 was Champakan Dorai region case. In case the fundamental rights are superior to DPSP, but they can be amended. Hence, there was first Constitutional Amendment Act. Then there were various Amendment Act for these 16 years between 51 to 67. In 67 came the Golaknath judgment. In that case, Supreme Court said that fundamental rights cannot, and I repeat, cannot be amended to give effect to any DPSP. Is that absolutely understood? Now, Parliament is saying that we want to give effect to preamble, that is justice, equality, social, economic, political, liberty of thought, expression, belief, faith, and worship, and to DPSP because both of them align more or less. But Supreme Court in 67 took all of it away. So this Constitutional Amendment Act, according to Parliament, was passed to reverse the Golaknath case. It declared that Parliament has the power to abridge, that is to take away any of the fundamental rights by enacting CAAs, and Article 13 is not applicable. So any of the fundamental rights can include Article 21, 22, 19, 14, 31, absolutely anything. And Article 13, thoda fundamental rights, remember the classes. What does Article 13 stands for? Article 13 stands for the definition of law. 12 stands for the state. So Article 13 says that any law cannot be amended so far as it can decrease the fundamental rights. But it said that this 24th Constitutional Amendment Act, Article 13 is not applicable. NA, you will fill various government forms, you'll know what NA means. So Article 13 is not applicable to any amendment which is made under Article 368. And finally, the most important point is President has to give his assent to Constitutional Amendment Act. Please remember this point, it is very important for MCQ. They will ask which of the following should President give assent to, or should not, can he exercise veto. So in this case, President cannot exercise veto. Okay, so after it is passed from both the houses, President has to give assent to the Constitutional Amendment Act. Then we have Article 368, which includes both the amendment of the process as well as the procedure of the amendment. So our 24th Constitutional Amendment Act said these 4 precedences and 4 guidelines. Now comes the 25th Constitutional Amendment Act. 25th, and they are just separated by 4 months period, not much. So Parliament, in order to overcome the obstruction, this is absolutely understood, the obstruction of 1967. So in enactment of social legislation, it passed the 25th Constitutional Amendment Act of 1971. By इसमें क्या किया? So what it did is curtailed the right to property, or it decreased the scope of right to property to very large extent, because it permitted acquisition of private property for public use. This is first time it is happening. Earlier it happened under abolition of zamindari, where ceiling were applied and land was distributed. So acquisition of private property by the government was done for public use on the payment of compensation, and the compensation is here. This is the key point, determined by Parliament and not the courts. Okay, so under Article 31C, so if the state has enacted any law giving the effect to the 2 articles under Article 39B or Article 39C, and in that process if the law violates the fundamental rights, is that absolutely understood, given under 14, 19, 31. So the fight is always between 39B(c) and Article 14, 19. 31 was removed later. So this is the fight. So it cannot be declared null and void, unconstitutional. N and V means null and void, merely on this ground. And finally, judicial review was taken away. Is that absolutely understood? So this provision is very important, because it is taking away the judicial review, because it says that any declaration to give effect to 39B and C cannot be challenged in court of law. So this is kind of a backside to Supreme Court. Now V.G. Ramachandran, he described 24th and 25th Amendment as it is not merely tinkering with the spirit of the Constitution, but it is a veritable slaughter of the Constitution because it is taking away judicial review. Because balance between legislative, executive, and judiciary is the critical, harmonious principle, and it is extremely important. So it is taking away, and the judiciary is becoming slightly weaker. So the 25th Amendment, according to him, smacks of totalitarianism, and it is signaling a hurry to achieve socialism instantly. Anyways, but for the first time in Indian democracy, independent India's democracy, two directives which were under the 39B and C, they are given precedence over three fundamental rights under 14, 19 and 31. 14 is equality before law, 19 is right to freedom, 7 freedoms, and 31 is right to property. They were 7 earlier, it was made 6 later. So now as you can see, fundamental rights run subservient to DPSP. This is the first time it is happening. 51 में हमने देखा fundamental rights were better than DPSP according to court. Then fundamental rights became far superior than DPSP. Now for the first time, fundamental rights are slightly on a lower side. Then comes the holy date of 24th April 1973, and the greatest thing that happened to India happened. What happened? Any guesses? This man was born. His name is Sachin Tendulkar. Okay, just kidding. We'll deal with this. This was the thing. Kesavananda Bharati case versus State of Kerala in 1973. So, what was the judgment? This, please remember these three lines. If you can't remember these three lines, just remember this 5 words. Certain principles of Indian Constitution are inviolable. They cannot be amended and are called as basic structure. Please remember these 5 points. They cannot be amended even by Parliament. Parliament has wide powers. Supreme Court agreed. Absolutely no doubt about it. But it did not have the power to destroy or emasculate. It cannot take away the soul, the heart, the spirit of the Constitution. It cannot touch these basic elements or fundamental features of the Constitution. Although it upheld the 2A and 2B part, and the first part of the section 3 of the 25th Amendment were upheld. Supreme Court did not. This is called as case by case basis discussion. Only that part which is in contradiction will be taken care of, and this is followed in law very commonly. However, the second part of section 3, which prevented judicial review of any law to give effect to DPSP, was declared unconstitutional and null and void because judicial review is basic structure of the Constitution. I'll describe basic structure in next slide. It is considered as the landmark decision of Supreme Court. What do you mean by landmark decision? They are the key defining moments in a democracy. They define a new law principle. They give a new hope, or something drastic happens. Example I can think of is Morgan versus Virginia, where the racial segregation law of 1946, it was held unconstitutional. Then you have Connecticut law. In that case, abortion plus contraception, this was held to be in Connecticut, it was held to be illegal before that, but Supreme Court ruled that right to privacy overrules this law. Hence, this was given to the citizen and they had the right to choose contraception. This is not very late, this is just 60 years ago. So on the basis of 25th, so this is called as the landmark decisions, and it happened just by wafer thin margin of 7 to 6 judges. It was a 13 judge bench, out of which 7 ruled in favor, 6 ruled against, and they outlined the basic structure doctrine of the Constitution. Since most of the provisions of 25th Constitutional Amendment Act were not removed or not held unconstitutional, hence the Bank Nationalization Act as well as Privy Purses Abolition Act were held to be constitutionally valid, and they were reenacted. Absolutely understood. Okay. Now this judgment of Kesavananda Bharati case has gained widespread acceptance over the time and legitimacy due to its again and again it comes in subsequent cases and judgment, and this basic structure keeps on enlarging. Kesavananda Bharati is the case which saved Indian democracy according to the Hindu, which came in April 2013 while I was preparing on the occasion of the 40th anniversary. And thanks to Kesavananda Bharati, who was the litigant, and it is his judge Nanabhai Palkiwala, and finally the 7 judge who were in the majority. So now moving forward, what do you mean by basic structure doctrine? So I have already told you certain elements of Indian Constitution which are inviolable, they cannot be amended even by parliament, they are called as basic structure. Certain elements of Indian Constitution inviolable, cannot be amended even by parliament, basic structure. Please remember this sequence as it is. What are the so these include, basically I can divide into 5 categories. First is the preamble objectives, obviously secularism, rule of law, sovereign, socialist, democratic, republican structure, unity, integrity of the nation, freedom and dignity of the individual. They are obviously basic structure of the constitution, you cannot tinker with them. Then we come to the constitution itself. Supremacy of the constitution is the number one. Article 32, which is right to constitutional remedy by Supreme Court. Article 226, same by High Court. Then essence of other fundamental rights of Part 3. Then Part 4 DPSP, that is the concept of socio-economic justice to build a welfare state. Then this is the most important harmonious portion, that balance between Part 3 and Part 4 of the Constitution. So please try to remember as many of you as you can. It can come in the short note, what do you mean by basic structure doctrine, or it can come in MCQ, which of the following are basic structure: 1, 3, 4, 1, 2, 4, 1 and 4, all of the above, none of the above, something like that. Then in judiciary we have the judicial review, obviously. Then the limitations upon article 368, you just can't amend anything. You can't say tomorrow there'll be no Supreme Court of India, just can't do that. So amendment has to be limited. Then we ought to have the independence of the judiciary, as it was long said back, it's a long legal concept, that legislation and executive are like the implementers while judiciary is like the umpire, so it needs to be independent. Then there is the principle of equality, which is mainly the quintessence of equal justice. Not all the principles of equality, but this portion is very very important. Then obviously access to justice should be there, right to legal aid, etc etc. We have NALSA and SALSA for that. Powers of the Supreme Court under Article 32, obviously I have already told you what is 32, 136, 141 and 142. Please read about them, they are extremely important. Under Article 32 they have right to constitutional remedy. Then these are the miscellaneous principles, that is the principle of separation of power, extremely important. Legislative, executive and judiciary shall be separate more or less. Then we have the federalism, then the parliamentary system of government, principle of free and fair elections, and finally if a state is passing the judgment under arbitrational tribunals, so you can't nullify those awards. Then we have the now till now what is the condition? So Supreme Court has again brought JR back. So now this is the emergency time from 25th June 1975 till 21st March 1977. For 1 year and 9 months it was the emergency period in India. So during that time 42nd Constitutional Amendment Act was enacted and it amended Article 31C. It amended almost everything in the constitution, that is why it is called as mini constitution, but I will be talking about only Article 31C here. So it says that if the state enacted any law to give effect to, अभी तक क्या चल रहा था, 39B and 39C, okay, this was till now, but it says all or any of DPSP, it goes beyond, it goes way beyond, and if in the process it violates 14, 1931, it cannot be declared unconstitutional and void merely on this ground. Okay, so now what happens? All the DPSP gets precedence over 3 fundamental rights under 14, 19 and 31. All DPSP, this is the keyword, all DPSP over 3 fundamental rights have precedence. So now for the first time DPSP are far stronger than fundamental rights. This is thanks to 42nd Constitutional Amendment Act. But when the new government came in power, what it did is it passed 43rd and 44th Amendment Act to reverse most of these provisions. So the 44th Constitutional Amendment Act 1978, it did lot of things like the president needs to take assent of cabinet before applying for emergency, and it removed Article 31 right to property from the list of fundamental rights, etc etc. Similarly, Supreme Court in Minnerva Mills case, what it did that it held the changes introduced by 42nd Amendment Act as unconstitutional because it disturbed the balance between Part 3 and Part 4 of the Constitution. And as we have already seen, the balance between them is the basic structure of the Constitution. So you can't take away the basic structure of the Constitution. So the final summary which emerges is there is no absolute power of Part 3 and Part 4 over each other. They are complementary to each other. and the goals which are set out by the DPSP have to be achieved. There is no doubt about it. But the means cannot take away the fundamental rights. Please use this line, you will get good marks. Fundamental rights are very, very important for individual expression. However, for community and societal goals, we need to focus on DPSP. Both are important. None can take extreme, overriding, absolute, comprehensive authority over other. Now, power of parliament to amend the constitution is limited. Finally, this is the point, and it cannot amend constitution to make this power unlimited. This was the line which was used by the Supreme Court. Although parliament can amend anything, but it cannot amend the constitution to make this power unlimited. Is that absolutely understood? So it has to be exercised in a limited sense. Absolute power corrupts absolutely. So you do not have absolute power anywhere in the world. So finally, this is the present status as of 2015, that fundamental rights are above DPSP slightly, but it does not mean that Parliament cannot give right to 39B and C over 14 and 19. So to implement 39B and C, what is 39B and what is 39C? So 39B says that should be equitable distribution there, and 39C is that the source of generation and production should not be concentrated. So it says it emphasizes that there should be equality, and it emphasizes that there should not be inequality, and there should not be concentration of production resources. So to give effect to them, example MGNRE, GS, etc., etc. So article 14 and 19 can be violated, and it can be done even today. So this is the exception which I was talking about. 14 and 19 can be neglected to some extent to give effect to article 39B and C in DPSP. Finally, what are the sanctions behind DPSP? What gives power to DPSP? So the constitution itself by part 4 obviously. Then there is public opinion. Public wants these DPSP to be implemented. Hence the government is accountable to them. Then there is some utility of the directive principles. Obviously, that's why they exist, which I'll be talking about in the next video. Then various constitutional amendment act, they keep on introducing new and new DPSPs, like 86th introduced article 45, right to education. It decreased the age to less than 6 in DPSP, and 97th introduced 43B, right to form cooperatives. 42nd introduced 4, etc., etc. Then the laws made by the government, obviously, like MGNREGS, PHCs, maternity relief, Janni Suraksha Yojana, etc. And finally, the executive orders. These give sections to the DPSP. So I hope you enjoyed the video. Do let me know either on the Facebook page or on the YouTube or on the Twitter. Please, please, please spread the word as much as you can and help those who cannot afford coaching. Thank you for watching the video. Have an awesome day.